If you're an entrepreneur, you have to learn how to win in business using contracts. This is Contracts 102. I'm going to talk about 3 advanced mistakes that entrepreneurs make when it comes to contracts so you can stop making them. I'm Karam Nahas, the 20-year battle-tested lawyer. In this video, I'm going to cover 3 advanced contract mistakes that destroy entrepreneurs that you haven't heard anywhere else. So stay until the end. I've got a free gift for you. But before we jump in, I've got a free personalized legal risk analysis for your business. It'll literally take you 5 minutes. It's a $7,500 value if I did it for you in person, but it's completely free. I trained AI to do it. The link's in the description below. Let's jump right into it. Number 1, advanced mistakes entrepreneurs make is you can't prove damages. Here's one of the most important things I can tell you about contract litigation or any sort of court litigation. Every legal case comes down to 2 things. That's it. Only 2 things: liability and damages. Liability means, did someone breach the contract? Did they do something wrong? Damages means, what did that cost you? How are you damaged? And can you prove it? So this simplicity in approach to legal cases is something a lot of lawyers don't understand. So entrepreneurs may have liability locked in and may be clear the other side obviously breached the contract. They feel like they've already won. But if they can't prove damages with legal certainty, they can't win. The case falls apart because damages need to be proven with certainty. That's a legal standard, and it's one of the hardest legal standards to meet. Think about it. If your client breached your contract, what did that actually cost you? Lost a profit. How do you prove that with certainty? You need an accountant, forensic accountant. Reputation damage. How do you put a number on that? Lost opportunities. How do you prove deals you didn't get because your reputation was damaged? Most of these damages are speculative, and speculative damages don't win cases. You need experts, and even then, if they can't show you with certainty, you lose. You need to define damages in the contract before the dispute happens. That's called liquidated damages. I'm sure you've heard that, but you don't really know how it's used and why it's so important. Liquidated damages means that you and the other party agree up front. If the contract is breached, the damages are this specific amount of money. It's predefined, it's pre-agreed, it's certain. Get it? That's certainty. So now when you get to court, you don't have to prove what that breach cost you. You don't need the forensic accountant. You don't need all these crazy experts. You just point to that clause. The amount is already in the contract. It's so easy for the judge to decide. The other side already agreed to it. That's why liquidated damages is so important, especially when it comes to IP issues. I've had to have that conversation over and over with business owners in court. So for a liquidated damages clause to be enforceable, you need 2 things. Number 1, actual damages were difficult to estimate at the time the contract was signed. That's like damage to reputation. Number 2, the amount is a reasonable forecast of actual damages. It's not a penalty. It has to be a forecast. That's what the restatement says for contracts, and that interprets the law. It's better to be safe than to be sorry. So advanced mistake number 2 about entrepreneurs, they don't know about equitable relief. They don't really know about chancery court. Most entrepreneurs think about contract disputes in only one way, and it's the wrong way. They think civil court, let me go get money. Someone pays someone at the end. That's not true. There's no cash register at court, and that's another video. That's one of the most limited ways to think about contract relief, and it leaves your most powerful tools completely unused. So let me tell you about what equitable relief is all about, why it's the most powerful protection available to entrepreneurs in a contract dispute, and why you need it in your contracts now. Equitable relief means you're asking a court to do something for you, not to give you money, but to enforce a contract, to freeze assets, to give you access to books. You can get a receivership that puts a court-appointed person in control over a business or assets if you think your partner's doing something fraudulent. You can go get emergency orders that gives you immediate access to things that you need, because that's what a court of equity does. They have a lot of tools and they can move fast. You don't have to wait for trial. You don't have to wait for discovery. There's expedited discovery. There's orders to show cause. I've done all that stuff. It gets a little complicated, but the fact is you can go into court quickly. You can get creative with your relief. You can get a judge to really get into your business, save your business, and that's all done in equitable court, a court of chancery, probably in federal court sometimes. It's not done in a civil court where all you're doing is going to get a money judgment that you may not even be able to collect on. So let me give you like a real case scenario. Your business partner takes confidential client lists, and now they start a competing business. So if you go to civil court, you're waiting months to get in front of a judge. By then, your clients are gone. The damage is done. You're just asking for a money judgment. The court doesn't really have power to do anything else. But let's say you go into a chancery court and you ask for equitable relief. You file for an emergency injunction. You could be in front of a judge in days. The partner is immediately barred from using your client list or contacting your clients while the case is pending. And now you got the judge on your side already. That's the difference between equitable relief and money damages. That judge can do so many things. It's in their discretion. It can stop the damage. It can compensate you. You don't have to go in front of a jury. And they have all sorts of creative mechanisms to help you. And they understand business a lot better. But to get quick access to equitable relief, you need to have the right language in your contract. You need a clause that specifically provides for injunctive relief without requiring a bond. You don't want to have to post money to do all this. You need jurisdiction language that puts you in the right court. You need provisions that make your case for irreparable harm clearer and easier for an order to show cause to get accepted in the court. Without these provisions, you're fighting for access to these tools on top of fighting the underlying dispute. And if you get stuck in civil court, you're really going to get no relief. Equitable courts, chancery courts, federal courts, know they exist, know how to get there, and make sure your contract gets you there fast, has the right language to get you into those courts and to get you the right relief in those courts. Because there's a lot of creative relief. You can get there. I've done it. Trust me. The judge has tremendous discretion, and they're a lot more helpful for your business in chancery courts than they are in civil court. So if you found that valuable, hit the subscribe. I break down legal strategies like this every week so you can stay out of court and learn from the mistakes of others, not the hard way. Here's the third advanced mistake entrepreneurs are making. You're relying on AI, Google, or LegalZoom. Now, this is a mistake I see the most often, and it's quietly destroying entrepreneurs and contracts everywhere. You needed a client contract, so you went to Google, or you asked ChatGPT, or you bought a template from LegalZoom. And now you have a document. It looks like a contract. It has clauses. It has sections. It has legal sounding language, whereas, wherefore, and you have no idea, though, if it will hold up in court. You have no idea if a lawyer wrote it, if a battle test lawyer, if someone with court experience and business experience. You don't know their background. You have no idea if that court's going to work, if it's court proven, if it's battle tested. You have no idea the background of the author. Have they been to court? Are they an entrepreneur? And here's what AI doesn't know. Here's what Google templates don't know. Here's what LegalZoom also really can't tell you if they've never litigated cases. None of these people or things knows what happens inside real courtrooms. The vast majority of legal disputes are settled confidentially. That's like 95%. They never become public records. They never become case law. They never become training data. ChatGPT doesn't have access to it. So what a judge said in chambers about how they interpret scope of work language, all the good stuff, all the secrets, that's not in a database. You don't know how contract disputes get resolved. What arguments worked in a contract dispute in your jurisdiction 2 years ago, you have no idea. That's not in any database. Like I said, only the trials. How a specific clause got torn apart in front of a specific type of judge, how a judge looked at it, what language should have been changed, what actually triggered the settlement. You don't know any of that stuff. That's battle-tested knowledge. It only exists in the experience of lawyers who've actually been in those courtrooms, who've litigated matters. AI contracts are inherently generic. They're trained on general language. They're ambiguous. They're not your specific industry contracts. They don't have specific jurisdiction terms, and they don't understand your specific risk profile. And generic language is ambiguous. And if it's inconsistent with other terms in the contract, you got a big problem, especially with a good litigator on the other side who knows how to use inversion. You understand what I mean? So LegalZoom, they give you a template written by a lawyer that you've never met. You don't know if they've ever been in a courtroom. You don't know if they have business experience. You don't really know if they're battle tested at all. You can't call them. You don't know anything about them. They don't know anything about your business. They're just giving you that template, and that's how they do it. And that's not complete legal protection for entrepreneurs, really. That's just legal paperwork. Those are templates, and there's a big, big difference. The contracts that actually protect you are written by someone who's been in that courtroom. Trust me, that's who you want. Someone who's seen how language gets interpreted under real pressure. And it's not in case law, like I told you. A battle-tested lawyer, somebody with business experience and courtroom experience, because you need both of that. And ideally, somebody who actually understands your business. That's the way to do it. And anything short of doing it this way is gambling with your business. Relying on LegalZoom, relying on chat, relying on Google. Trust me, like I say, you don't want to F around and find out with your contracts. Here's the bonus. Here's one more mistake entrepreneurs entrepreneurs make. Most entrepreneurs sign a contract. They never look at it again. They never look at their old contracts, and that's a mistake. Your business changes, your services change, your clients change, your experiences change, your risk profile changes. Always update your contracts. Keep up with them. Hire a professional to audit your contracts. You have no idea what kind of gems and good stuff that can come out. At least once a year. Every time you add a new service, update your contract. Every time you enter a new market, review for compliance. A contract that was solid 2 years ago might have gaps today, especially now that you're thinking defensively. You understand inversion. You understand how to scrutinize contracts and look at it. And on top of that, I'm giving you a free gift like I promised you. It's the Ultimate Client Contract Checklist. Every provision that we've talked about that you need for client contracts is in this checklist so you can legally test your own contract. Make sure it's battle tested now before it's too late. It's completely free. It's in the link. It's in the description below. Grab it. It's the Ultimate Client Contract Checklist. I sell client contracts. They're legally bulletproof. They're battle tested. You can also get a free personalized legal risk analysis of your business built by me, the 20-year battle tested attorney. It literally take you 5 minutes. It's a $7,500 value if I did it in person for you. The link is below. I trained AI to do it. So if you want the contract that covers everything that we talked about for your clients, plus 2 months of having direct access to me, that's right. You get to talk to me directly, Q&A, get training for your contract, get to ask me questions, talk about your business. I'm the lawyer who wrote it. You can have that. It's part of my client contract system. The link's below. And remember, I am the battle tested lawyer. Defense wins championships. It's your job to get legally bulletproof.